Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Itchon, Senior Vice President, and with me is Tim Anaya, Senior Director of Communication.
Well, Ro, I don't know about you, but I'm basking in the glow of a great gala that we had this weekend.
Yes, it was really fantastic. And it was so good to see you, Tim. I never see you much these days other than the electronic version of you. And who knows if that's really you there.
Exactly. But it was nice to have a crowd of free marketeers in person and just to get together. You know, if you feel like it's a little more sense of normalcy to have events like that again.
That's right. And we had it in Orange County. There are no mask mandates. There's no vaccine card checks. So it was a semblance of normalcy that we haven't seen in a long time.
And we heard a great presentation from Molly Hemingway talking about her new book and weighing in on all the craziness that's going on in Washington these days. And then we gave our Baroness Thatcher Award to Larry Elder. So it was great to see him say a few words.
Yeah, so it was really a fantastic evening. And for those who missed it, we're back in action, and we'll be having more galas. We had to take a pause in 2020, but we're already planning for 2022. So we look forward to seeing you all.
And I'll put in an early plug. Save the date for Thursday, February 17th for our next annual California Ideas in Action Conference that'll be held in Sacramento. And we'll be in person once again. So if you're in Northern California, come see us. We'd love to have you there in person. All your events are happening right here at CRI.
That's right. So, Tim, last week, the state's redistricting commission released its draft maps for the House. Now, some of our listeners know that the congressional districts are redrawn every 10 years based on the recent census. And California lost a congressional seat. So now we only have 52 seats versus the 53 that we had in the past. I'll give a little background on this. So every state decides how to redraw their own lines. And California, back in 2008, to avoid gerrymandering, created the Citizens Redistricting Commission, which includes 14 volunteers who represent diverse political views and from different parts of the state. So that comprises of the commission. And last week, they had the first draft of the congressional seats. It looks like Orange County is going to feel the loss here. It looks like the seat held by Representative Alan Lowenthal will be going away based on this draft. Also, Katie Porter's seat, the 45th district, is overpopulated now based on the 2020 census count. So that means her district needs to shrink while the others grow. So the Orange County representatives like Katie Porter, Young Kim, Michelle Steele, might be playing musical chairs a bit. Looks like they don't even live in their districts anymore if this map stays. So there's going to be a lot going on there.
What's also interesting here in the Sacramento area, there's been a lot of criticism of the commission's work. One of the commissioners was quoted during, they actually did the line drawing live online. So if you needed the cure for insomnia, you could have watched it home and followed along. And one of the commissioners reportedly called their entire draft map effort a hot mess. And one of the hot messes is in the Sacramento area where literally, even though they're not supposed to gerrymander, kind of looks like gerrymandering, they literally drew the capital city in half. So if you're familiar with downtown Sacramento, literally like one side of the Crocker Museum at 3rd and P Streets is in one district, and another side of the Crocker Museum is in the other museum. And interestingly, even though if you're a congressman, you don't actually have to live in your district to run there, 4 members of Congress would live in the same district in the Sacramento area. So Doris Matsui, Ami Bera, Tom McClintock, and I believe John Garamendi were the 4 that all live potentially in the same district if these maps hold. And that's a key thing to note. There's going to be a lot of feedback on these maps. There will be a lot of changes. The commissioners say that they, will be making changes. So if I were an incumbent worried about these maps, I wouldn't call my real estate agent just yet. But as the final maps will be released right around Christmas, you might be looking for a moving van come the new year.
Yeah, and we'll definitely be following this on Right by the Bay blog. And listeners should know that it's not just going to be congressional districts. It's also going to be redrawing the California's Senate's 40 seats and the 80 seats in the Assembly. So that's going to be happening in the next few weeks.
I saw one statistic in the draft lines that were released. 28 current Assembly incumbents are in their proposed new districts are nested in with a colleague. And I believe it was 12 or 13 Senate incumbents were nested in with a colleague in their proposed new district. So, and you do have to live in your district to run for the legislature. So if you want a good line of work come January 2022, you might want to be a real estate agent offering your services to incumbent state legislators in Sacramento.
How does that work, Tim? Is there going to be a lot of wheeling dealing among the Assembly members? You get this, I run there, blah, blah, blah. I would imagine that's what's going to be happening behind the scenes.
Well, I can't divulge any gossip that I'm hearing, but I'm hearing a lot of gossip and it's already going on now. But again, you shouldn't make any firm decisions yet because these maps will all change and in some cases significantly. But you, especially if you're an incumbent, you need to be out in front of this and planting your flag and, making your intentions known because you're literally off to the races. The filing for offices, I think the filing deadline is sometime in early March. So you're really off to the races if you need to move, establish residency and plant your flag in a new district.
So our upcoming guest is an interview by Evan Harris, who leads our Young Leaders Circle community. So Tim, how about introducing the next guest?
So Evan, it's a really interesting discussion. He chats with Alicia Jessop, who's a professor at Pepperdine, and she's a noted journalist and lawyer and writer and thinker on all these issues related to athletes and the law, and especially student athletes. So there's been a huge debate over whether college athletes should be compensated for their name, image, and likeness. Up until now, they haven't been. And so thanks to a Supreme Court decision earlier this year, and actually, and this is a rare case of California leading the way with a change in the law a couple of years ago.
Positive change in the law.
A rare positive change in the law pushed by a very liberal Democrat senator. Now, student athletes are able to be compensated for the use of their name, image, and likeness. So you've been seeing, for those who follow college athletics and follow college athletes, I see on Instagram all the time, Keaton Slovis, who's a quarterback for USC, you will see now he has deals with clothing companies, and you're seeing all over that student athletes, and not just in football, in soccer, in, Olympic sports, and both male and female athletes are finally starting to earn, some compensation for their name, image, and likeness. So it's really the ultimate free market at play. And so Evan and Alicia talk about all of these issues and what's happened up until now and the potential for what will happen going forward. So if you're interested in these issues, it's a really fascinating discussion.
Thanks, Tim. So here's Evan and Alicia.
Hey, everybody. Thanks for joining us. Have a really great series for the Wild Sea Speakers Series today, a part of Pacific Research Institute. We're going to talk a lot about the NCAA. We're going to talk about the new compensation. Folks commonly refer to it as NIL, or name, image, and likeness. And we have someone straight from the source. She used to be a sports writer. She is an associate professor at Pepperdine University, and Alicia Jessop. Alicia, thanks for being here.
Thank you for having me.
So Alicia has written, she helped author one of the congressional bills, written in Harvard journals. She teaches sports. You're also a lawyer too, right?
I am a lawyer.
A little bit of everything.
California and Colorado. And I'm still a sports writer.
So she is probably, dare I say, an expert on the topic. Well, let's dive in. I think that's something, unless you're following it or you're in college sports, folks might not understand what the Supreme Court case was and what the change was. So could you walk us through that?
Yeah. So what's going on in college sports as we approach the fall and the return to hopefully a quote normal college football season? it might look a little bit different this fall because your favorite football stars are going to be driving to the stadium in new cars that they've obtained through sponsorships. They're going to be feeding their offensive linemen at dinners that the university is not providing, but that they've obtained through sponsorships. So how did we get here? The NCAA was founded over 100 years ago, and what precipitated its founding was in the year leading up to 1906, 18 young men died playing college football. The sport was widely unregulated, but our president at the time, President Roosevelt, loved the sport. Essentially, he recognized that if regulations were not put in place, the sport would probably go away. So he convened together a group of leaders in Washington, D.C., and what emerged from their discussions was the need for a policy center for college sport. The next year or so, an organization was founded that in 1910 would become called the National Collegiate Athletic Association. Since that time, the NCAA has grown to 1,200 member institutions across all 50 states in 3 divisions of athletics: Division I, Division II, Division III. Central to the NCAA's role is creating bylaws. So it has 3 different rule books for those divisions. These rule books span hundreds of pages long. Yeah. Division I, a central bedrock to Division I athletics is this principle called amateurism. And broadly stated, what the amateurism principle says, up until July 1st, 2021, is all a college athlete can receive in exchange for their athleticism is a college scholarship. So this is the way it's been for nearly a century. Yep. But beginning in 2009, the NCAA began facing a number of lawsuits challenging the legality of that amateurism principle under federal antitrust grounds and state right of publicity grounds. The first lawsuit was filed by former UCLA men's basketball player Ed O'Bannon. That case made it all the way to the Ninth Circuit. In 2014, another case was filed called Alston versus NCAA. It was filed on the first day of March Madness in 2014. And unlike O'Bannon, which involved a lawsuit by a former NCAA athlete, the Alston case was brought by 5 then current NCAA athletes in revenue-producing sports. I'm not going to get into the nitty-gritty of that case because we have a joinder with another case. We have some settlement of the case. Long story short, the case reaches the United States Supreme Court this March amidst the coronavirus pandemic. The makeup of the Supreme Court in 2021 looks markedly different than it did in 2014. Arguably, we have a more conservative-leaning court. A lot of these cases filed against the NCAA, they have a lens of civil rights issues. They have a lens of fundamental fairness. But also central to the cases is free markets, is the opportunity for college athletes to compete in a free market to benefit from their name, image, and likeness. So the United States Supreme Court in June of this year, June 24th, 2021, issues their ruling in what is now called the NCAA versus Alston case because the NCAA petitioned to the Supreme Court for review of the Ninth Circuit's ruling. This is an antitrust law case alleging that the NCAA limiting what a college athlete can receive to a scholarship amounts to price fixing. The Supreme Court hands the NCAA a 9-0 loss. It's unfathomable. It's very rare that the Supreme Court agrees, all 9 of them. We have very differing philosophical views on this court. All 9 justices determine that the NCAA limiting what college athletes can receive to a scholarship violates antitrust law. So in the wings of this decision is a law that was enacted in 2019 in California, Senate Bill 206, better known as the Fair Pay to Play Act. In 2019, California became the first state in the nation to restore to college athletes their right that every other citizen in the state has, that right being the right of publicity. California gave the NCAA up until 2023 to come into compliance with the law. In the meantime, other states realized that this was a competitive issue and that if California had this law, but they didn't, they were going to lose top recruits to California. So two of the most competitive football states in this nation are California and Florida. If you look at which states produce the most NFL talent, it tends to be those states along with Texas. Yep. Florida enacts a bill after California that would go into effect much sooner than California's on July 1st, 2021. So the Supreme Court's decision, while on its face, did not allow college athletes to profit from their name, image, and likeness. All that case allowed for was college athletes to receive unlimited benefits tethered to education. It did mean that there was a ruling on the books by the highest court in the United States that the amateurism standard violates antitrust law. And so what it did is it ripped apart any defense or any legal strategy that the NCAA would have to go into individual states and sue to enjoin the enactment of these individual name, image, and likeness laws. So that's where we are today. That is a very long-winded answer to your first question, so I'm going to pause now.
No, I think it's good history, and I think it brought up, was it an oversight by the NCAA to petition, thinking that the Supreme Court, maybe through historical precedent or previous cases, they just assumed they would side with them using I think it was the amateur ruling. And then they pretty much, 9-0 from any Supreme Court ruling is unprecedented these days, but for it to happen on someone petitioning the court to get a ruling looks like they messed up.
It was beyond messing up. It was frankly a point of arrogance. Yeah. The legal case that the NCAA argued, and the NCAA had some of the strongest lawyers in our nation. It's not like they went to a local law school and gathered a legal team of interns. Their Supreme Court argument was argued by Paul Clement, one of the most respected attorneys in this country. He argued bad law. He argued dicta from a case in 1984 called Board of Regents of the University of Oklahoma versus NCAA. So they were relying on a bad analysis of antitrust law precedent. Yep. And that's how you get to where we are today. Frankly, I'm not sure why they petitioned the court. Perhaps they truly did believe that they had a winning case. And I honestly think that's what it is, because other circuits have ruled differently than the Ninth Circuit, namely the Seventh Circuit has ruled differently on similar issues, but the Seventh Circuit is essentially in the NCAA's backyard. And so it's going to be a little bit more favorable to the association than the Ninth Circuit, which is in California. So I think there were a lot of upset people in Indianapolis on June 21st, 2021. Well,
PRI has always supported the free market approach to student athletes. So I'm okay if they're upset.
Cheers, PRI. That's awesome.
And it's funny, you talked about the California law and fair pay to play. We wrote up that in 2019, and we are free market. We're a little more critical of some progressive policies in California, but that one we're like, you got this dead right. This absolutely needs to be done. Like, great law. And you're right, it did kind of start the wave that I was surprised it was as quick as it was, but it definitely, once other states saw California, everybody has to do it.
But it's the purest study of a free market.
Yeah.
Because what Nancy Skinner did in drafting that bill is she removed a market restraint, an artificial market restraint. This is the one place in the United States where it's still okay to literally not pay your labor.
Yeah.
Yes, I'm still paying student loans. I understand the value of a free education.
Yes.
And student athletes are receiving immense value from the scholarships. However, they're also driving immense value for the NCAA, which as an association generates over $1 billion in revenue, and alongside its member institutions accumulates $26 to $27 billion worth of revenue each year. Yeah. So what the Fair Pay to Play Act did is it removed that artificial restraint partially because individual member institutions still cannot compensate via a salary their student athletes,
Yes.
but remove part of the restraint. And what you see when that happens is you see competition emerge. And so Florida knew that if it didn't react to what California did, it was going to lose out on the best student athletes in this country. And now we have a situation where student athletes in all 50 states are engaging in their name, image, and likeness right.
Well, let's go into a little bit of that. Name, image, and likeness has been on the books for a couple months, and we've seen some of the articles. The recent one I saw was, I think Dr. Pepper had signed somebody. There's local, you talked about barbecue joints. I think it was the University of Arkansas had signed the quarterback and offensive lineman. It was for like a barbecue or like a buffet restaurant, which is great marketing, pretty genius. That the Alabama quarterback, I think Nick Saban was quoted that he's close to, I think, $1 million. Do you think it's working as anticipated, or are there any surprises that you've seen?
No real surprises. I do think it is working as anticipated. I think for me, I've worked in sports for over a decade. What perhaps is surprising is the number of college athletes who are getting deals. If you study sport endorsements, I think there was this belief that every professional athlete has endorsements. That's really not true. If you study the endorsements that most professional athletes have, they come as a result of what is called group licensing, which is where the union is assigned rights from the athletes to go into the marketplace and secure sponsorship deals that require the whole group to enter into them. So these would be things like trading cards, video games, collectibles, etc. Most of your professional athletes, if they have an endorsement deal, it typically comes through group licensing. It's only your premier athletes that have the car deal, the body wash deal, the consumer goods deal. So I think the biggest thing that's been surprising to me is we're seeing a wide gamut of college athletes secure endorsements. And why I think that is really boils down again to free market economics, where some of these smaller companies did not have the marketing budgets in place to be able to offer a professional athlete a sponsorship deal, but they do recognize the value of sport marketing and being aligned with people with strong brands. And they could use their smaller budget to secure a sponsorship with a college athlete. So that's what I think is happening there. Today's August 12th when we're recording this, and a new exciting opportunity was released today where a restaurant called Walk-Ons is offering a deal once a week throughout the college football season to a walk-on athlete. So we're literally seeing every range of athlete getting in on this opportunity.
No, that's great. And I think about, I went to school at University of Oregon, football players, women's softball, baseball, track, which big at Hayward Field. There are a lot of smaller businesses that would love to probably hire a fan favorite who's maybe not the star quarterback, but he's been there for 5 years and he's, whether it's like a nose tackle or the best softball pitcher or the best hurdler, who maybe wouldn't get the same exposure, and have them come to the restaurant, come to a car dealership, come to an event, whatever it is. And I mean, to me, looking at it and when PRI looked at it, those were the real opportunities. And it was the smaller market, the smaller dollar that local businesses and the smaller athletes would benefit from.
I agree completely. And I think that's the real story here that a lot of entities aren't focusing on, because it's a lot sexier and a lot fun to talk about the car that the Pittsburgh quarterback received. But truly, what I think has been handed to college athletes as a result of this legal right being restored to them is they get to begin building their own personal businesses today. Being athletic is a gift. I don't have that gift. You can't see me. I'm 5'4". Somehow I was a college cheerleader, but I topped out around 18 in terms of my athleticism. There is a short window of opportunity to expend this athletics gift.
Absolutely.
And some of them are going to expend it by securing millions of dollars worth of endorsement deals. Hopefully those people too, but more so everyone else has an opportunity to build a business around their name, image, and likeness. In the digital world that we're living in, that is a legitimate business. My dad retired last year after 40 years working at Coors Brewing Company. He went to a physical factory plant every single day to perform his job. In the new world that we're coming into, that's not what it's going to look like. And so if we can teach these young people how to build a personal brand that exists online, they can build a solid financial future for both themselves and their family. So I think that's going to be the bigger story coming out of this, is the business lessons that these young people are being given that they can carry with them well beyond their athletic career.
And I want to get to it because we're short on time. You wrote about, there isn't an impact, but you wrote about Title IX and what role, or not really role, NIL could play in that. Could you go through that?
Yeah, so Title IX is a piece of federal legislation that was initially enacted in 1972. It was applied to sports in 1975. Broadly stated, what Title IX requires as it relates to sports is in federally funded educational settings, the genders need to be given equal opportunities to compete in sports, equivalency of financial aid, and equal treatment as it relates to athletics. There were some people who, as NIL was coming down the pipeline and as the reality was surfacing that college athletes would be able to profit off of their names, images, and likeness, there were some people who were waving flags saying, if we do this, it's going to further set women back. And their argument was that most brands are going to want to partner with the star quarterback, the star point guard. Athletics departments are going to align most of their funding to educating male sport athletes, predominantly in revenue producing sports, on how to optimize this right. And it's going to push women even further behind the starting line than they already are. Women still face grave disparities when it comes to publicity in sports. Recent research shows that women's sports only receive 4% of advertising exposure and television time. We know this is true when I turn on to ESPN2 when the WNBA is playing, but I see a cornhole match that men are competing on in my screen.
Yeah.
So this is a problem. It is a legitimate concern. In the article that I wrote for the Journal of Legal Aspects of Sport, I do believe that the concern is a bit unfounded or ungrounded, because here's what these people are failing to realize. Who has been promoting women this entire time, so during this 50-year window, that they have not received fair exposure? It's men. It's men. If we look at who leads athletics departments, if we look at who is the CEO of television networks, if we look at who the chief marketing officers are of corporations, by and large, it's men, and it's Caucasian men. We have seen that when women have their rights restored to them to go into the marketplace and profit from their name, image, and likeness, they do infinitely better than when they leave those rights in the hands of the male decision makers. Case in point here is the United States women's national soccer team. So in 2017, when that team was crushing it, they were winning on every stage. Their group licensing rights and their right of publicity were held by US Soccer. And so what that means is it was US Soccer's job to go out into the marketplace and secure endorsement deals for these women. These women were at the top of their game. They were the most visible women's soccer team in the world. US Soccer secured literally zero group licensing endorsements for them. In their next collective bargaining agreement, the women took back those rights from US Soccer. They gave their group licensing rights to an organization that was founded by the NFLPA. Okay. That organization bullishly went out into the marketplace and secured numerous deals for these women. And so I think it's very short-sighted to say, well, if we give this right to college athletes, the men are only going to get further ahead. Sure, the way that the system works might allow men to continue on their trajectory. You might have athletics directors and chief marketing officers who want to continue the status, but we've learned that this system doesn't work for women. And so women can either keep playing in the system, or they can say, nope, we're going to take our power we're going to take what is ours and we're going to go into the marketplace, the free marketplace, and we're going to find our own deals. And you are seeing female college athletes do that. Some of the most visible athletes to take advantage of this right have been women athletes, and that's inspiring.
And I would think NIL would, and you're saying this, but it would open the opportunities. It would make even more opportunities for that. And
it does.
For
it does.
them,
And
for a company to come, or real quick, and I'll let you finish. There was an article, and I think they play for Fresno State. They're basketball players, and they, through, I think it was TikTok or Instagram, they have it was like glass companies or a watch company, but I think it was like $30,000. It was a lot of money, and like those opportunities, I mean, you wouldn't have had that without NIL or any other agreement, probably.
Completely. And I think, so those are the Cavender Twins. They're basketball players at Fresno State. And women, if they're able to get their business ducks in a row, female student athletes actually have a better opportunity to monetize their brands than men, because they have more followers on social media. If you look at TikTok and Instagram, in the article, the example I use is UConn basketball. So UConn is a unique case study because that men's basketball program and women's basketball program, they're both very successful. So I looked at the Instagram followings of athletes from both genders teams. The women outpaced the men's Instagram followings by large. So Paige Buchers, the star basketball player on that team, she has one of the biggest followings in all of intercollegiate sports. Okay. That's what brands want. Brands are wanting to leverage the social media followings of this young group of Generation Z members to tap into their market and to share about their brand. So women can definitely benefit from that. It's a great opportunity truly for everyone. And again, I think the best thing to come from this is we've known for a fair amount of time now. I'm a professor. I highly believe in higher education. However, we know that there's some holes in higher education. We know that only 40% of college graduates leave our campuses with any basic financial literacy skills. Yeah. We can begin curing that gap by instituting education through name, image, and likeness classes to at least cure that gap with college athletes. So that's a huge opportunity.
No, that's actually a great point that hasn't been shared. So I think we're running out of time. So where can folks find your work? Where can they visit what you do, stay in touch with you?
So the best place is on Twitter. My Twitter account is @RulingSports, like illegal ruling, sports with an S. That's my Instagram too. I'm not on TikTok yet because I have privacy concerns, but I feel like I might be driven there shortly. So yeah, I hope you follow along. You can also read my work in The Athletic and The Washington Post.
Great. Well, Alicia, thanks for joining us. It was great insight and great information. Thank you.
Thank you, Evan.
If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, TuneIn, iHeartRadio, and Spotify. And when you're on these platforms, don't forget to give us a big 5 stars. If you don't subscribe to any of these, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Ichon. Hope you'll come back again for next round with PRI.